my analysis on AI and IP too is done in 3 different buckets. And the way that I approach it is examining, okay, what stage of AI development or deployment am I looking at? And for that purpose, the 3 buckets I look at are the input stage, the AI tool development and refinement stage itself, and then the output. And so those 3 buckets individually require their own analysis in terms of an IP rights. So going back to what you were talking about with databases, inputs are necessary for a model to be developed in the AI or machine learning world. And in the US, we don't have protection for databases for the most part. It's really difficult. We don't protect the underlying facts. We protect the arrangement. We protect some of that to a degree. But if you contrast that with the EU, they have the sui generis database rights, where they do actually recognize protection of the underlying facts.
Welcome to Tech Intersect. I'm your host, Tonya Evans, and my life and work exist at the heart of law, business, and technology. Yeah, I've earned a few fancy titles and degrees over the years, but the bottom line is I'm a writer, speaker, teacher, and lifelong learner, and I'm really excited that you've joined me on this journey. So what is Tech Intersect? Well, it's authentic, empowering conversations with really interesting guests who demystify complex topics to prepare you for the future, because your future is now. And it exists where law, business, and tech intersect. Get ready to listen, learn, and leverage. Let's get started. In this episode of Tech Intersect, I am speaking with Franklin Graves, my Twitter bestie, also a Nashville, Tennessee-based in-house IP counsel and member of the technology law group at HCA Healthcare. And he previously held roles on the commercial legal team at Eventbrite and business and legal affairs team at Naxos Music Group. And Franklin is currently co-chair of the Copyright and Emerging Technology Committee of the ABA, that's the American Bar Association's section of intellectual property law. And fun fact, he mentors and provides career and professional guidance to law students. I love that as well. And young emerging lawyers as they navigate law school and the legal profession, respectively. And another fun fact, his resume building bootcamp course on Udemy has provided valuable career guidance to nearly 2,000 students worldwide. And I invited Franklin on to discuss the legal issues impacting creativity, ownership, and control in the new creator economy. We'll talk about all of that and more in a moment. But first, Franklin, welcome.
Thank you so much for having me. I'm very excited to be on. I can't wait to talk through so much. I've been a longtime fan of yours, following you on Twitter, seeing you pop up in interviews all over the place. It's exciting to be able to talk to you and also be a part of your community with your podcast.
Absolutely. I think this is going to be such a great conversation for folks. They will be learning through my questions. I asked you if we could, in addition to some of the broader legal issues that creatives need to pay attention to on the IP side, in this fantastic space that I feel like you've coined the phrase. And so as IP lawyers, game recognized game, I respect a good trademark and all of that. But this idea of the creator economy law is not just something that's made up, but it really is critically important to understand how creativity and distribution and monetization of intellectual property generally, but copyright in particular, is critically important. And you live at the intersection of all of those things. So I really wanted to unpack what's going on with AI as well. Artificial intelligence is all the rage. It's almost as if it was created this year. I assure you all it was not, but it's starting to mature, right? It's starting to mature. And so this is a really great opportunity now that it's in the headlines to figure out what that means for creativity and distribution and monetization of copyright. So let's get into it. I always spend time on your timeline on the Twitters, but also on your blog as well. And if those things are any indication, clearly your expertise and your zone of genius lies in exploring and analyzing the legal issues surrounding the creator economy, right? So that includes, I suppose, internet creators, internet platforms as well. And given all of the complex IP contract, other thorny issues in Web 2 and 2.5 and 3, there are no shortage of topics to unpack. Talk to me before we get into some specific topics, what a day in the life is like for you as a creator economy lawyer.
Yeah. So I think personally, my background, I grew up just always tinkering, building websites, building my own computers, being a part of creativity that melded with technology. So whether it was building out my own GeoCity websites or exploring what HTML, how do you write HTML? And then along came CSS. It's always been this journey to explore, understand how is technology driving creativity and how is creativity also driving technology and backwards. So for me, it just became a no-brainer when I went to law school that I was going to find a way. I like how you say the heart of all these, and I use the word intersection of all these areas in my life and in my profession. And it's just kind of, I feel like over the last year and a half, I've kind of found my groove. And I found that creator economy law was a way for me to focus on two things that I understood really well and combine them together. And creators have been around for a really long time. And I think YouTube was probably one of the first ones to coin the term within the creator economy itself. And also at the same time, providing a platform for users that are generating content to earn revenue from that content and a share of that revenue. So creator economy is a mix of both creators that are creating and earning ad revenue shares from the platform itself, but also working with brands, becoming the influencer, or maybe getting a commission on sales if they go that direction. There's so many different ways to slice and examine creator economy. And that's one of the reasons why I love writing about it. There's always week to week something to write about. The other distinction there too is the platform side of it, the technology powering it all, how platforms choose to roll out updates, change their algorithms. All of that is impacting creators. It's impacting brands. It's impacting the audience. We as users of the platform. The ecosystem is so heavily reliant on all those other aspects. I love dissecting that each week. So that's kind of where I came from in terms of my background and kind of how I've found a way to meld it and mold it into my career path as well.
This is a really important service from an education point of view, because your point is well made about user-generated content, or UGC, and the idea of moving like from Web 1.0, where we were the passive recipients of information, or we could access information, but weren't at the time involved in creating. And then all of this creativity, awesomeness started to explode in Web 2.0, which of course presented its own new issues of the ability to, on an easier basis, make perfect digital copies, disseminate those perfect digital copies of MP3s under the guise of sharing. It was a love-hate relationship with that terminology, right? And then like peer-to-peer software and apps, Napster, Grokster, all of that, BitTorrent. So even at the Web 2.0 level, it presented these new interesting questions and challenges around the law kind of incrementally evolved, but there were, and we have a long way to go, but there were so many new people who had no idea about the copyright ramifications, but just knew that they could leverage technology to do some really cool things. But it came with consequences, right? That they were then held to the same standards of making sure they weren't inadvertently infringing on someone else's rights, or maybe the other side of it as well, that people weren't creating maybe technological fences where the law would allow for fair use, right? So this ebb and flow and the balance, I imagine now it's even more challenging to do as we get into bigger decentralized protocols in my world. But then when you also just think about like artificial intelligence, for example.
Yeah, exactly. I think the distinctions and having that foundational understanding of, like you were just talking about, Web 1.0 being more of a information highway, one-way directional sending information. And I even mentioned, like, I grew up more so in I would say maybe Web 1.0. It wasn't really Web 2 because it wasn't really that interactive. It was still a static website you were building. I was just interacting with the hosting provider at that point. So I think even now, I think the argument is that we are in a Web 2.5 stage. We're kind of in this in between, trying to figure out still what Web 3 is going to look like, how it's going to be built, who the major players are going to be. And if anything, I'm looking at it as well from the creator economy viewpoint of you have these institutional platforms at this point, whether it's your Meta and their platforms of Facebook or Instagram or WhatsApp, when you have Twitter and you have YouTube, you have Google, and you have these institutional players, even down to like WordPress and Shopify, that maybe aren't ready to move into a full Web3 experience because they haven't figured out how to monetize it. They haven't figured out what their business model looks like in those spaces in that new environment. And it really impacts creators as well, because at that point, where does the funding come from? How do you share? And I know that I've followed you a lot as well. And I know you've talked about NFTs and the possibilities that that technology unlocks with the underlying blockchain transactions as well. And so how do you merge all this together while also still recognizing Google doesn't want to give up their fight and their control over the ad ecosystem? I mean, we're seeing, and to tie that in with AI, we're seeing that happen now. Microsoft's coming out the gate swinging, being like, nope, we're going to challenge you with AI and open AI integrations and all of that. So come at us. Mm-hmm. But it's more of, I'm still looking at what is going to be that driver into a full Web3 experience. And then also how do creators go along with that? And what does it look like for them?
Talk to me about, you wrote recently on your blog about the Copyright Office and its take on artificial intelligence and whether creativity or something that's literary or artistic and fixed in a tangible medium of expression and therefore capable of copyright protection. If it happens to be AI generated, is it analogous to the case where the monkey takes a selfie and then the owner of the monkey wants to register? Right. I know PETA had something to say about that. What's going on the AI side?
Yeah, well, the Naruto case is very important and a very important distinction to make. That was a more recent example of the Copyright Office reinforcing this underlying baseline principle that human authorship is a requirement for the ability to copyright and claim copyright ownership. Otherwise, the work is arguably in the public domain. It's not eligible for copyright protection. So that's kind of where we stand. That's been a long history of that, as your listeners probably know and can remember or recall. But the nuances that we're seeing now are where creators are using tools that have an AI element to them. And so it ranges. And in one of my articles, we can maybe put it in the show notes, I referenced and created this creation generation spectrum where I lay everything out along a spectrum from left to right. So on the far left, you have me standing in an auditorium, no equipment, nothing. I'm just doing an acoustic set. It's just me and my voice, or it's just me and a piano. And there's no tools involved. And even a next step up from that might be an artist using a paintbrush, an artist using tools, maybe using equipment, using recording equipment. And you can go and follow that along even further to, okay, where they're using a computer now, or they're using Photoshop. And Photoshop has automated tools that can rotoscope and do fun stuff like that. Like I said, technology driving creativity and creativity driving technology. And where we're getting to really rapidly, especially in the Christina Castronova case, they are pushing the Copyright Office to make those distinctions and to determine, okay, what is the appropriate level of human authorship if you are using an AI tool? And that's just simply not a question that we've gotten answers to. And the Copyright Office is luckily working on guidance they're going to release later this year in 2023. But on the other end of the spectrum, too, I want to highlight another case is Dr. Stephen Thaler, who he's an engineer, software programmer, and he created a creativity machine. That's what it's called. And it's this algorithm, the software that is text to speech, and it will output an image. And he submitted that registration for the copyright application. And if your listeners may or may not be familiar, but when you register a copyright, you have to list the owner of the work and the claimant. And the owner of the work would be the author, the human author that created it. And the claimant would be the person that is submitting and claiming the work. And so what he did was filed it and said that this was not a human author, that it was the software. It was a machine generated image, but he was the claimant and claiming ownership of it for that purpose. Of course, the Copyright Office is not going to register that, and they didn't. And it resulted in a back and forth a couple times with their office and getting different opinions. And now it's resulted in a lawsuit as well, because ultimately the Copyright Office said, no, we're not going to register this. So he sued. It's in federal court right now. To Chris Castanova's case, that one was a graphic novel that they created. And the graphic novel had a couple different layers to it, I guess, digitally as well, if you think about it that way. It had the text, it had the story, it had the panes and the panels for the comic, the graphic novel, and the underlying artwork, the images. And the images were created using Midjourney. Midjourney is an AI tool that you access through Discord, and you do text and give it text prompts, prompt engineering, and it will output an image. And you can take that image, it'll give you a couple different images, and then you can keep refining your prompt. And that's kind of, if you look at the response that their counsel gave to the Copyright Office, they detail out exactly how much human involvement there was in generating those images with Midjourney as their tool. They took it into Photoshop, added elements to it, refined it, all of that. And that's how they ended up with the images that ultimately comprised this arrangement of a graphic novel. And that's kind of what the Copyright Office hit on, was this is more of an arrangement. You can't claim ownership of the underlying images because there wasn't sufficient human authorship. Where that line is drawn, again, remains to be seen. But then they're able to maintain ownership, and the registration will be corrected and refiled to cover the story and the arrangement of those images in the story and the text as a graphic novel. So a lot of interesting questions and nuances along the lines of that.
You love listening to podcasts, but have you ever thought about starting your own podcast? Maybe you want to build a brand, grow your business, or are looking for an excuse to talk about your favorite hobby. Whatever your reason for making a podcast, Buzzsprout is the place to start. Since 2009, Buzzsprout has helped over 300,000 people launch their own podcasts. Buzzsprout walks you step by step through the whole process and will give you powerful tools to start, grow, and monetize your podcast. Ready to get started? Click the link in the show notes to get our free step-by-step guide to starting your podcast today.
Hi, I'm Dr. Tonya M. Evans, author of Digital Money Demystified. And I want to let you know that to stay on the leading edge of any opportunity, especially investing, you have to empower yourself with the tools and resources needed to keep your knowledge and skills current. And if you're relying on last year's information or even last month's, look, you're already behind. Sure, you can try to figure this out on your own at YouTube University. The problem is, it's difficult to separate fact from fiction with so many carnival barkers banking on your inexperience. And of course, there are the naysayers, usually from legacy finance, banking on your fear, while they quietly help their high net worth clients to invest. All of it muddies the waters when all you want to know is how to get in safely, legally, and confidently so you're not left behind. That's why I wrote Digital Money Demystified, where I take the top 10 crypto myths head on and give you well-researched, well-supported facts to empower you to make good choices out there in the new digital cash economy. As a law professor who developed the first blockchain crypto and law online certificate program, a retail and corporate crypto policy and education trainer, and a thought leader appearing regularly on national media, I've done the heavy lifting so you don't have to. Look, there are plenty of books and courses on which crypto assets to invest in. Digital Money Demystified is the book you read before you dive into those. So head to digitalmoneydemystified.com to learn more and prepare for the future of money and wealth today. Yeah, that's really fascinating because it makes me think of those seminal and important cases out of the world of copyright, where sometimes the underlying work itself isn't subject to copyright protection, but there can be, it makes me think of databases and the selection, arrangement, and coordination. And so that could maybe be another way to reach it, where the separate parts in and of themselves may not be subject to copyright protection, but because of the selection and the coordination and the arrangement, that happens all the time with databases. That can happen. I think of like a photography case, some of those old cases as well. And so it's interesting again to see 20th century for the most part, 76 Act, right? And it's like, I don't know, like a mummy at this point. Not Frankenstein, not a mummy, a Frankenstein. right? I don't know. He's just going to keep wrapping them up and sending them out to stumble forward as it feels like technology is moving at an even faster clip. And by the time guidance comes out or rulemakings and new laws, we've moved on to the next. And so it really presents very pressing legal and policy issues. Do you have any thoughts as a matter of policy, what the ideal balance might be if we, lived in a perfect world now to, for limited times, whatever that means, give this economic incentive in the United States for people to create. Creatives create just because, right? I'm a creative. I used to be a performance poet back in the Def Poetry Jam days. Fun fact about me. Story for another day, another topic. But yeah, so I definitely understand that point of view. For limited times, the benefit of monetization, and kind of talked about that earlier, what that looks like. The theory, at least in the United States, is to incentivize, if not creativity, at least the dissemination of creative works, right? It's this idea of like, we're going to separate this out from the public domain for quote unquote limited times. And then eventually it will return so that we'll all enjoy it. But in the process, that is how society advances, right? That's the promotion and progress of arts and sciences. But it's a long way around to say, what are your thoughts as a matter maybe of just policy of how you can incentivize people in an increasingly decentralized world that also is opening up a global world where we're all interconnected?
Oh, I love the fact that you mentioned that it is a global world, and that's what we're facing, especially with decentralization. I'll answer your question through a couple different ways. And I think policy-wise, Europe is again leading the way. And I say again, because you might be familiar with 2018, we had GDPR. And that came into effect, I think it was May 2018. And that caused a firestorm, a ripple effect around the globe in terms of what websites needed to be doing, what technological measures were in place when it came to guarding and safeguarding an individual's privacy and recognizing that they might have decisions that they want to make in terms of how their activity, their user interactions, all of that is tracked and stored and accessed and shared and sent all over the globe. So I almost want to recall what we learned through that process, because right now,
right, or didn't
exactly. And I think that's where I'm going is, if you look at California, if you look at the lack of any federal level uniformity on the privacy front, I'm afraid that we are very rapidly going down that same path where, from an IP standpoint, we have this mishmash of laws and approaches. Like the EU is already working on an AI Act. They already have AI mentioned in some of their newer legislation that's been enacted, the Digital Markets Act, the Digital Services Act, as well as the Digital Singles Market. All of this internet regulation, it touches on copyright law, and it touches on these fundamental IP considerations that we in the US are still trying to grapple with. And I think that's what the Copyright Office and the PTO are working on, in terms of they've sent out requests for comments, are gathering information. NIST is working on their standards. You have all these different governmental agencies working on things. But I think fundamentally, it's going to take legislation. It's going to take action. It's going to take various interest groups coming together and deciding, okay, what do we want for the future? And that gets to your other point of, okay, where's the incentive going to be? What will the incentive be for me as a creator to continue creating? And I think that leads me into another discussion that I would just really quickly share with you, is my analysis on AI and IP too is done in 3 different buckets. And the way that I approach it is examining, okay, what stage of AI development or deployment am I looking at? And for that purpose, the 3 buckets I look at are the input stage, the AI tool development and refinement stage itself, and then the output. And so those 3 buckets individually require their own analysis in terms of an IP rights. So going back to what you were talking about with databases, inputs are necessary for a model to be developed in the AI or machine learning world. And in the US, we don't have protection for databases for the most part. It's really difficult. We don't protect the underlying facts. We protect the arrangement. We protect some of that to a degree. But if you contrast that with the EU, they have the sui generis database rights, where they do actually recognize protection of the underlying facts. Also, with the UK, they have the text and data mining exception. So there is a research and I think it's academic exception to be able to crawl the internet and scrape data and build a data set that way without a license or without permission. And so you have all these different varying approaches to laws. In the US, Microsoft was really well, like they have been fighting, or their subsidiary LinkedIn was fighting against a company called HiQ that was going and scraping profiles from their website in violation of both their terms of accessing the LinkedIn platform, but also I think in the lawsuit, it's really important to reference and recognize that they were even bringing CFAA claims, so the Computer Fraud and Abuse Act claims, which are serious issues. And all of that combined really leads to this interesting analysis of, okay, how do you ethically and sustainably build a data set that is large enough and sufficient for purposes of training a model, and then getting to the next phase of actually having that model and then building algorithm, building software to interact with it and use the model and input prompts or do fun stuff with it and do next level research. And that's the second stage is like, okay, what's the tool? What are the terms of Midjourney? So I think it's interesting with Midjourney in particular, they have two different tiers for using their terms of service. You have a paid tier for corporate members where you get more rights, or if you're just using the free paid tier, you get like a Creative Commons license. So that's another IP analysis there. And then the final one is the output stage. So we were literally just talking about, okay, from a copyright standpoint, can you own the output? And it's not just copyright, it's patent too. So a lot of algorithms, a lot of work being done with machine learning and AI models are exploring patentable subject matter and getting to the point where you might end up with an invention that could be patentable. But how do you do that if in the US we have a requirement for human inventorship? That's where we stand. And it's interesting too, because right now, Dr. Thaler, I mentioned on the copyright side, he's also pursuing a lot on the patent side and getting a patchwork of decisions from various jurisdictions where, okay, some recognize that a machine can be the inventor, or some jurisdictions are saying no. Like in the UK, just like a couple of weeks ago, there were oral arguments, whatever the equivalent term is for that in the UK, where they were arguing and they were explaining why an inventor should be a machine and that should be recognized. It's opening up all these different questions. And I think from a policy and regulatory standpoint, those are the three buckets that need to be examined. But then I would layer on top of that, from a regulatory standpoint, you have to look at what is the purpose, what is the end use of the tool. And one last thing I'll say is, with an example is the Midjourney tool, the DALL-E and DALL-E 2 tool from OpenAI, or even Microsoft now has rolled out their image generation stuff. And I think Google announced something today where it's this interesting question of, okay, we have the tools where we can generate these outputs, but at what cost? What are we taking away from the artist and the creators that their images were scraped and not licensed to build an algorithm? And yeah, there might be arguments that people are making about, oh, there's a fair use because of how the diffusion model works. It's a transformative use, and maybe Warhol will tell us. But I think ultimately, my personal viewpoint on it is getting that end question of why. What is the end goal here? And keeping in mind as well, the counter question to it is it truly ethical? Is it truly sustainable to be building these models that recreate or replicate creative works that artists and creators were never compensated for or never even gave permission over?
From the beginning, and then it just compounds.
Yeah.
This is really fascinating because it makes me think, for people to say, well, how could something other than a human do X, Y, and Z or have rights? It's like, well, corporations evidently are people too, and trusts, and we have imbued inanimate objects and things created with the mind with rights all the time. And so it's not as cut and dried as one might think when you first say it out loud. On one hand, there are many people who said, of course it can. On the other, you spoke very eloquently about the ways that tools have been used to create, to innovate, to take an inventive step. Right. It makes me think of the patentability of software, for example, difficult, but not impossible to do. So yeah, we really have to stay on top of this. I hope you'll come back every few months or so. And because things move so quickly, we're having this conversation now in March. By December, who knows if we'll even be here on Earth? I don't know. We might be, I don't know, swept up. I don't know what's going on.
Maybe Neuralink. Maybe we'll all have our
But
Neuralink implanted and
1,000%.
yeah.
And it'll be a much better place. I don't know. It's TBD, as they say on the Bird app and everywhere else. Franklin Graves, it's been an absolute pleasure. Please tell the listeners how they can learn more about you and the creator economy law.
Yeah, thank you. So I can be reached at creatoreconomylaw.com or on LinkedIn. It's just Franklin Graves. And that's actually where I have my newsletter, the Creator Economy Law newsletter. And I kind of piggyback same stuff on the website as is available in the newsletter, but the newsletter happens every week on Thursdays. So subscribe there. But otherwise, yes, on Twitter, that's where we are on the Bird app. I'm at Franklin Graves. I'm pretty easy to find. It's just my name.
Awesome. Sadly, I'm highly Googleable as well. So definitely find both of us and let's continue the conversation. Be sure to like, comment, subscribe, share, and let's stay on top of this AI generated work. It's really, really fascinating. And I see it as this incredible tool to continue to make things better, more efficient, clearer, better, faster, cheaper. Is that how we say it? But definitely, it's not about getting Pandora back in the box. It's like, let's figure out how to do this and to leverage technology to make the world a better place. I don't think that's, utopian. I think that's just the next right step. What do you think?
Yeah, I would agree. I definitely, I know I probably sounded very anti-tech to a degree in terms of maybe I would argue I'm less that way. I'm more of like, let's pump the brakes. Let's figure it out from a policy standpoint. Because again, I think I hear a lot from companies touting sustainability, touting ethics when it comes to a whole broad array of areas and bias when it comes to AI and ML technologies. But I definitely see the benefit to being able to quickly research and have an algorithm or have two algorithms fighting each other, pitted against each other, and you do like a GAN to get them and figure out, solve the world's next disease crisis. But I think that, like I said, the particular use cases is where I'm focused on, really kind of diving in and understanding, okay, there are a lot of non-IP infringing use cases and opportunities
Uses.
and uses and for the betterment of society uses. But I would question whether or not it is worth giving up the rights of a creator to have somebody just be able to add to their PowerPoint slide deck with a click of a button, a rabbit eating a marshmallow, because it adds something to their presentation.
Right. It's on one hand, the liability of the harms and like the overall benefit. We have all these balancing tests. My head is starting to explode as a law professor and you as a practitioner. Excellent. Well, we will keep the conversation going. Franklin Graves, thank you very much.
Thank you so much.
Thank you so much for listening to the Tech Intersect podcast. I hope you enjoyed this episode. If you love it, please tell the world. If not, go ahead and tell me. And in either case, drop a comment or ping me on social media at IPProfEvans with the hashtag TechIntersect. And finally, a quick reminder on digital safety. There are a lot of scammers out there impersonating me and others, and I need your help. Now hear this, and remember, I will never slide into your DMs to say peace and blessings or hey, and I will never reach out to solicit your time or your money on social media, like ever. I'm not a trader. I am an educator and an attorney licensed in 4 states. Thank you very much. I'm here to inform, inspire, and empower. No cap, and definitely no Forex. So be careful, make good choices, and remember, I developed an entire free masterclass about the topic of digital safety in the crypto space. So check out secureyourcryptobag.com for more information. That's secureyourcryptobag.com. All right, that's all for this episode. Until next time, continue to shine.